Hello, everybody, and welcome. We are going to go over some new orders that have come out from the judge in the Chad Daybell case. We did watch his last hearing, and there were some things that the judge had taken under advisement, which means that he would give a ruling at another date. We do have some of those now, and we're going to go over them. So I'm going to ask, if you have not subscribed, please subscribe to the channel. Hit that notification bell to make yourself aware when I go live, when I do updated reads, when I do updated court orders, court cases like this. We will be covering this Chad Daybell trial when it starts in April. We are going to be allowed to stream it, so we will be doing that. Also, please give this video a like and consider donating to the channel to help support us. It would be much appreciated. There's a little heart just below the video where you could donate there, or PayPal, whichever is best for you. It's not required, but it is very much appreciated. It helps me to continue to bring these things to you. Okay, so let's get into this, you guys. His trial is set to still start April 1st. So let me bring this up for you. Okay, here we go. Let me just make this full screen so you guys can see it all. Okay, so the first document that we have is the estate's motion to reconsider the change of venue. So on November 15th, and we seen that hearing, we watched it right here, the state of Idaho filed a renewed motion to reconsider a change of venue. The defendant, Chad Guy Daybell, hereinafter called Daybell, filed a response and objection to the motion on November 17th. On November 29th, the court called the matter for a hearing. We also seen that one. The court orders now as follows. Background. On May 24, 2022, a Fremont County grand jury returned an indictment charging the defendant and his alleged co-conspirator, Lori Vallow Daybell, with multiple crimes, including multiple counts of conspiracy to commit the crime of first-degree murder. Daybell was also charged with several counts of first-degree murder and insurance fraud. On July 21st, 2021, Daybell filed a motion requesting a change of venue. The state objected to that request on September 29th, 2021. On October 5th, 2021, the court heard argument and received evidence on the motion. The court entered an order granting the defendant's motion for a change of venue. More particularly, the court ordered that the trial be transferred to Ada County to ensure due process in finding a fair and impartial jury. On February 17, 2022, the state requested the court to reconsider that order, or alternatively, to import a jury to Fremont County for the trial. In an order entered on April 28, 2022, this court maintained its previous determination to transfer the trial to Ada County. Subsequently, Daybell sought and obtained a severance of his trial from that of his co-defendant and alleged co-conspirator, Lori Vallow Daybell. Vallow Daybell's case proceeded to trial in Ada County, and it was held on March through May of 2023. A jury returned a verdict against Vallow Daybell on May 12, 2023. On July 31st, 2023, the court sentenced Vallow Daybell. Now, we do know that Lori has been transferred to, I think, Arizona. She's going to be facing 2 first-degree murder charges there and conspiracy and everything charges there also. So she is already over there. I do believe if you check in my community tab, I did post it there. So keep an eye on the community tab, you guys. I did have a fall last week. I'm still trying to recover from that. I'm not supposed to be sitting for long periods of time. So there's that. This is the first day that I've jumped on to YouTube. So please take that in mind. So anything new, I do try and post there if I can't do a video. So keep an eye on that community tab. Daybell's trial is now scheduled with a jury selection to begin in March of 2024. And jury selection to begin, I was going to say that's wrong. His trial is set to begin April 1st, April Fool's Day. And ironically, Lori Vallow's trial is set to start April 4th, 2024 in Arizona. So jury selection is going to start in probably the last week of March of 2024 and evidence beginning on April 1st, 2024. The state filed the instant motion requesting that the court reconsider the decision to transfer trial to Ada County, requesting instead for the trial to be held in Fremont County, or alternatively to again consider importing a jury from other counties in closer proximity to the Fremont County rather than administer the trial in Ada County. The state also alternatively proposes that the trial be held in somewhere closer to Fremont County, suggesting Bonneville or Bannock counties. Daybell maintains that Ada County is the appropriate county for trial. The legal standard. Now, I'm not going to read through all these different court cases that they may. I haven't read through this yet, you guys. But if they start citing other cases and that, I'm not going to read through all those because we're going to find out the order anyway. And it's just too long to sometimes go through all that. But Idaho Criminal Rule 21 details Idaho's guidelines for transfer and trial. Rule 21 states, in part, a motion for transfer may be made at or before arraignment or any other time the court or these rules prescribe. For prejudice, on motion of either party, the court must transfer the proceedings to another county if the court is satisfied that a fair and impartial trial cannot be had in the county where the case is pending. For convenience, on motion of the defendant, the court may transfer the proceeding to another county for the convenience of parties and witnesses and in the interest of justice. The analysts. A prefatory comment, the court will clarify the issue at bar. Defendant argues it is procedurally inappropriate and flawed for the state to request a change of venue. However, record reflects the correct posture of the pending motion. The state is asking the court to reconsider the decision to transfer trial from Fremont County to Ada County and return the trial proceedings to Fremont County. Given that procedural posture, the court finds the state's motion is appropriately considered and will be determined on the merits over the procedural objection of the defense. From the outset, this case has garnered significant media attention. Daybell's alleged co-conspirator was tried and convicted on all charges brought by the state of Idaho against her. While her trial was not televised, daily release of the audio was repackaged and broadcast by various media entities. Therefore, the analyst before the court is under Criminal Rule 21, whether the court is satisfied that a fair and impartial trial cannot be had in Ada County, where the case is currently set, to reconsider bringing trial back to Fremont County. The state argues that the trial of Lori Vallow Daybell conducted in Ada County was heavily covered across various media platforms in Boise and Ada County, and that the more recent media saturation there now poses the risk that the jury pool for Daybell's trial in that venue is likely tainted. The state suggests that given the trial publicity in Ada County earlier this year, Fremont County may now be a better venue for locating a fair and impartial jury. To support its argument, the state referenced the media coverage in Ada County, but did not provide further empirical evidence to demonstrate that media coverage during the trial of Lori Vallow Daybell has so saturated prospective jurors in Ada County that it's likely to impanel a fair and impartial jury. In fact, no additional evidence has been presented in support of the motion, which rests solely on argument. While the court may draw its own reasonable inferences based on the experience of residing in Boise during the trial earlier this year, such inferences are not as compelled as empirical evidence that could have submitted in support of the state's motion. Neither has the state demonstrated how that same extensive coverage has not also continued to inform and interest there's prospective jurors in Fremont County or any neighboring county in the 7th Judicial District. As the court mentioned at the hearing, it is likely that the sentencing of Lori Vallow Daybell on July 31st, 2023 was the apex of media coverage and public interest, and that hearing occurred in Fremont County. That hearing is also chronologically the most recent major event garnering such coverage in either case. The court will reiterate its position relating to the ability to conduct this trial in Fremont County. Absent the concern of locating a fair and impartial jury, the court has total and unequivocal confidence that the trial in Fremont County would pose no concern. This court presides over all felony cases and all district court civil cases in Fremont County. The court has conducted many trials in Fremont County. Never has this court found Fremont County jurors to be unable to honorably serve and faithfully discharge their directives to follow the law and instruction of the court to uphold the defendant's right to a jury trial with a fair and unbiased jury. In addition, any concerns raised over courthouse security or ongoing construction of the adjoining jail facility are without merit. The Fremont County Sheriff's Office is fully capable and competent to oversee a trial of this magnitude. That office has always provided exemplary security for the court, whether at routine criminal hearings, hearing days, or during heavily attended and emotionally charged hearings such as the Lori Vallow Daybell sentencing hearing, where heightened security risks are present. Further, that office provided personal security for the court beyond expectation. During the entire course of the first trial in Ada County, regarding the physical facilities, the Fremont County Courthouse is a notably beautiful and historic facility. The clerks are dedicated, experienced, and responsive. To summarize, absent the concern about selecting an impartial jury not tainted by pretrial publicity, Fremont County could unquestionably be an ideal venue for the upcoming trial. Nevertheless, the objective consideration of sheer population difference between Fremont County and Ada County cannot be ignored. As demonstrated in the companion case, a large number of prospective jurors will be necessary to summon qualified and question through the use of a questionnaire and both group and individual voir dire in order to ensure that the balance tips in favor of robust due process to Daybell, particularly in light of the potential for capital punishment. So we do know that he is facing the death penalty where Lori was not. The state presented no evidence to elaborate any concern that the pervasive media coverage has not inundated Fremont County jurors with pretrial exposure in Daybell's case and actual exposure to the presentation of evidence at trial in the Vallow Daybell case, of which the proffer to the court is that there will be significant overlap in witness testimony and other evidence. In addition, ironically, the sheer expense of litigating, oh my gosh, you guys, I'm so sorry, litigating this case and the companion case has impacted Fremont County financially. The financial impact becomes another source of potential jury taint, where hardworking citizens of the county are likely frustrated, and the prospect of paying for these cases resulting in further interest in following these cases, even if those citizens are less interested in the subject of the cases. The court has carefully considered the unfortunate reality that there will be an additional expense in again moving this second trial to Ada County. Finally, the court must consider empirical evidence that it does have before it that Ada County, the most populous county in Idaho, has the resources from a jury selection standpoint to impanel an impartial jury and is willing to provide the facilities and conduct the trial. The reality is, and the state would likely concede, that nearly every possible eligible working citizen of Fremont County capable of jury service has followed the Chad Daybell and Lori Vallow story. The discovery of JJ Vallow and Tylee Ryan's buried bodies on Chad Daybell's Fremont County property sent shockwaves through the community and propelled the case into the national spotlight. With the expense of conducting a trial in Boise is immense, it is still less expensive than attempting and failing to seat a jury in Fremont County, only to thereafter return to Ada County. Unfortunately, the court finds that scenario to be a distinct possibility. Finally, the state's request to consider alternative locations closer in proximity are not unreasonable. However, the extensive preparation and time involved administratively has been expended to preparing for trial in Ada County. At this time, with only a few months before trial begins, it would be impractical, if not impossible, to pivot to an alternative county and begin anew a complex machinations of administering a case of this magnitude and complexity. The logistics of hosting this trial, including the sheer length of the trial, place a burden on any hosting county. Taking over a main courtroom for months creates issues requiring extensive planning and preparation. Additionally, and again, on the consideration of costs, the court will note that Ada County made significant concessions that lessened the fiscal impact on Fremont County relating to the trial costs. It is unlikely that other counties would be willing or able to extend such concessions, especially on short notice. Thus, the court is not convinced that it would be any less expensive to host a trial in an alternative county. The court recognizes the sacrifices that are required given this difficult decision. For local prosecutors, there is a burden of having to relocate away from family and community for an extended time. That burden extends to others, including witnesses, victims' family, and law enforcement involved in security and staff. The court's decision allowing the live streaming of the trial will serve to lessen that burden to some extent. Notwithstanding, the court remains convinced that the proper venue for trial remains Ada County, and that a fair and impartial trial will take place there, as was accomplished in the companion case earlier this year. So the conclusion is, for the foregoing reasons, the state's renewed motion to reconsider a change of venue is denied. So he denied the change of venue. Just give me a second, you guys, because for this next part, I'm going to stand up for a bit because I can't sit for too long. I can't stand for too long. So the next one we have that was filed is an order on motion to amend the indictment. Now we know that Chad Daybell's lawyers filed a motion to amend the indictment. They said the wording and this and that wasn't right. So they thought about this motion. The judge took it under advisement. Now we've got the order. On November 11th, the state of Idaho filed a motion to amend the indictment. There was some wording in that they wanted to change because the defense was making a squabble about it. Defendant Chad Guy Daybell filed a response and objection to the motion on November 17, 2023. On November 29th, the court called the matter for a hearing. For the reasons stated on the record, the court will grant the state's motion, and the amended indictment is ordered to be filed in the case. Okay, so this is on defendant's motion in limine to limit the state's consistent arguments on the defendant's relative culpability. Okay, so what this is, you guys, we heard on the 29th, the defense was saying that, look at, in the Lori Vallow trial, they were putting most of the culpability onto Lori. She was the mastermind. If it wasn't for Lori, this wouldn't have happened. She was the connection to all people involved. She seemed to be the one that stood out. They said a bunch of things. And now Chad Daybell's lawyer is saying, well, now look at, it was also one of their arguments to have the death penalty removed because Lori didn't get the death penalty, but they claimed that the prosecution was saying that she was more culpable. I don't know if that was exactly said. I really didn't follow a lot of that trial. You guys had a lot going on. I did follow some of it, so I could comment on it. But what basically they're saying is if she, you know, if the death penalty was taken off for her and she was more culpable, then the death penalty should be removed from Chad, and they shouldn't be able to now change their directive when they are doing Chad's trial and try to say that Chad was the one that was more culpable. Like, but the defense has said they made an argument, like, look, they were both culpable. How we presented that case is the same way we're going to be presenting the case against Chad, et cetera, et cetera. If you haven't seen the coverage on that, you can go back to my video on November 29th, where we live streamed that whole hearing. So the judge said that he would take it under advisement, and here is his order on that. So on November 9th, the defendant filed a motion in limine to limit the state to consistent arguments on the defendant's relative culpability. The state filed an objection on November 22nd. On November 29th, the court called the matter for a hearing. For the reasons stated on record, the court denied the motion without prejudice, which means it could be brought back again. So they could, if they feel like during Chad's trial, because here you can say, you see, it's without prejudice. If they decide during Chad's trial that something is going askew, or that the prosecution is taking things from the Lori Vallow trial, which they deemed Lori Vallow was like the sole one to be accused of that, and now they're trying to put it onto Chad so that he can still fight if he objects to certain things. So they did it without prejudice. The matter could be revisited if necessary during trial to be heard outside of the preview of the jurors. So the defendant's motion in limine to limit a state to consistent arguments on defendant's relative culpability is denied. So the next thing we got now, you guys, is the notice of trial setting pretrial conference and scheduling order governing further proceedings. So this is what we have so far, you guys. This could change, right? I'm praying to God that the trial date doesn't change. I think that they're going to be ready to go. I also think we haven't got, put it this way, he has fought for the death penalty to be taken off the table. The judge hasn't made an order on that yet. Not that I've seen. Okay. That hasn't been dealt with yet. So I'm still waiting for that. I'm going to be watching for it this week. This past week, you guys, I haven't really been able to do a lot because I was on strict 4-day bed rest. I fractured my tailbone and another small bone in my lower back, which just added to the problems I'm having with a broken back already, which was higher up in my back. And thank God that wasn't affected as far as I know. I'm still waiting for my MRI. Anyway, so I haven't been able to follow it, but I am going to be checking in on it this week to make sure I'm kept up to date on this, to make sure, because I feel like he may end up making a deal. If the judge doesn't take the death penalty off the table, if he decides it stands, I think Chad may be trying to make a deal that he would plead guilty, but only if they remove the death penalty. That's just my opinion, okay? So with that being said, there's a motions hearing set for January 30th, right here. Motions hearing set for January 30th. Then we have a pretrial conference set for February 22nd. And then we've got the jury trial. They're saying it's going from April into May 31st. But we know that it's going to start in March, the end of March, with jury selection. Pretrial motions. So they're just going through here with the instructions that the parties must file at least 14 days prior to the day designated for hearings. And it's got to be a written motion or affidavit supporting the motion, memoranda or brief supporting the motion. And if any, the hearing is requested, the notice of hearing for the motion must be filed with the court and served so as to be received by the parties at least 14 days prior. The time limits herein do not apply to the motions and other matters if a different time limit is provided by statute. They're just going through the rules here, you guys. You can pause this and read this if you want. It's just going through the rules for discovery. All discovery must be completed and served on or before 5 p.m. on February 1st. That's 2 months before trial is to start. Expert witness deadlines. The disclosure of any expert witnesses must be completed and served on or before 5 p.m. February 1st. However, should either party disclose an expert witness after the 5 p.m. February 1st deadline, the opposing party shall have 30 days from the date of any such disclosure to procedural rebuttal, expert, or lodge an objection to the witness. Final pretrial conference. All parties shall discuss potential settlement of the case before the date of the final pretrial conference scheduled for February 22nd. At the final pretrial conference, the parties must be prepared to inform the court whether the case is going to trial. The defendant's appearance is required. So they have until February 22nd to make a deal if that's going to happen. I mean, I don't think that if they came the day before trial and said, okay, he's going to plead guilty, I don't think the judge is going to say, oh, no, we're going to trial. But they're trying to put a date here. I don't think a judge would ever deny somebody pleading guilty prior to a trial starting. But we don't know, right? But he's just given this final pretrial conference clause in here. Plea agreements. All plea agreements shall be reduced to writing. A written plea agreement shall be dated and signed by the attorneys for both parties and by the defendant. Okay. So I think that is put in there for a specific reason. This could be just the way it's done. It's put in there anyway. But I am thinking that if the judge does not remove the death penalty, Chad Daybell is going to try and make a plea agreement. And I think it's going to be, I'll plead guilty, you take the death penalty off the table. Because that's the only chip he has to bargain with. IC 18207, absence of showing good cause to extend the following time, written notice must be given at least 90 days in advance of the trial date if a party intends to raise any issue of mental condition and or call any expert witness concerning such issue. So 3 months before the trial date, they have to file any kind of notice if they are going to try and say that there is some kind of mental health issue that is going to be brought up. A motion to continue. All motions to continue the trial shall state with specificity any rationale in support of the motion, and it must be in writing. I don't know why these pages are all different sizes. Jury questionnaires. The proposed jury questionnaire is due to the court by January 5th, 2024. A close and seal hearing on the jury's questionnaire will be scheduled in January 2024, and a date and time will be determined by the court. Jury instructions. Proposed jury instructions must be submitted by the parties to the court by 5 p.m. on March 11th. Don't forget, I believe the last 2 weeks of March is when they're going to be selecting the jury. That's just my guess. Exhibit and witness lists. A list of all exhibits and witnesses shall be submitted by the parties to the court by 5 p.m. on March 11th. So everything is to be submitted. Like I said, you guys, I feel that if the judge does not take the death penalty off the table, I do believe that the defense is going to use that as a bargaining chip to, okay, we'll plead, but we want the death penalty taken off the table. So that is what I have for you guys today. I will be keeping an eye on this. If there is anything new, or if that is taken off the table, then I don't think that I will be able to sit or stand again for another video quickly. So please make sure you're subscribed, hit that notification bell, give this video a like, please, and share it out where you can. Keep an eye on my community tab. I will put any new information that comes out, unless I'm feeling up to being able to do another sit down. I'm trying to save myself because I didn't do the mini reads on Sunday, so I'm planning to do them either tomorrow or Wednesday. So I want to try and give myself a rest in between these, you guys, but I'm doing my best. So until the next time, you guys, I'll end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surrounding. I love you guys to the moon and back. Bye-bye for now.